Hello everyone, welcome back to our next session on patents as one of the important intellectual property rights. We have been going through in our last couple of sessions about patent, as to what is patent, what is the meaning of patent. Under the Indian Patent Act 1970, what is patentable? What are the four important criteria which any invention has to satisfy before it can be granted patent for a period of 20 years as an exclusive right to the patent holder? In our today's session, we will be studying an important concept which is granted to the patent holder as one of his option to commercially exploit his patent, which is known as licensing and assignment of patent. Now, as we all have heard about this word as to license, assignment, we will first try to understand what exactly does it mean. Let's say, for example, I have a car and I have the ownership of the car, and I have just given my friend my car to drive. So I tell my friend that you use this car for 2-3 days. Let's say my friend wants to go out of station, so I tell my friend you use the car for 2-3 days, and after which you come and park it in my house. In this case, what I am doing is that right of ownership is mine. How to use the car, who should use the car, where the car should be used, only the owner, that means only I can go on deciding it. So what I do is that I give my friend a car, that means I'm giving him a permission to use my owned property for some use or for some limited period of time. This is when you are giving certain rights of your, in this case the right to use the car. I am transferring that right to my friend for couple of days, after which the friend will give it back to me. In this case, I am just transferring the right to use the car, but I am not transferring the ownership of the car. Such type of arrangement under the patent regime is known as licensing of patents. On the other hand, the another concept is that of assignment of patent, wherein in this case I am not only transferring the right to use, right to make, right to sell, which are typically the exclusive rights granted to the patent holder, but in this case I am transferring the entire ownership and title of the patent to another party. Such type of arrangement under the patent regime is known as assignment of patent. So patent is considered as a transferable property which can be transferred from the patent holder to another person, or by operation of law, like we talked about compulsory licensing in our last session. It can be either licensed or it can be assigned by the owner of the patent, that means the patent holder. In case they are joint or co-owners, then a co-owner can assign or license the patent only upon the consent of another owner. It is just to make sure that one co-owner should not get the benefit without including the other co-owner or without taking the permission of the other co-owner. Now, like I said, the main difference between these two is transfer of certain interest in the property and transfer of ownership in the property. The property here means the patent. So, in case of assignment, the ownership and title is transferred to the assignee, whereas in case of license, it is only a right which is transferred to another person. For example, right to use or right to sell or right to make, otherwise which would have amounted to infringement. So if you remember, when we talked about certain exclusive rights which are granted to the patent holder, we said the patent holder gets a right to exploit the patent holder gets a right to grant licenses or file a case for infringement, or to surrender, use and enjoy the patent. Such rights are granted only to the patent holdee. So if I have to transfer these rights to, or one of the right to any other party, it will be considered not to be an assignment, but it will be considered to be a license. Now, in case of a license, the patent, in case of assignment, the person to whom the property is transferred is known as an assigner, whereas in case of license, it is a licensor. In case of assignment, the person to whom it is transferred is known as assignee. In case of license, the person to whom it is transferred is known as licensee. Under the Indian Patent Act, predominantly the assignment related portion is covered under section 68, which talks about creating of any licenses, mortgages, or creation of any interest in the patent. Now, the section 68 goes on laying down certain requirements. Only and only if these requirements are satisfied, it will be considered to be a valid transfer of interest. Now, be it assignment or license or mortgage, it should be in writing, and it should go on detailing all the terms and conditions with respect to the rights and obligations of the party. Now, to give you a small example, let's say I have invented a new laptop. That means whatever current laptops we see, I have invented some new laptop related technique or machine, the product, and I have got a patent from that, for that product, from the patent authority in India. Now, what I can do is that either I can start my own manufacturing unit and start manufacturing these laptops, but if I don't have that much capital, if I don't know the exact niche of manufacturing, what I do is that I appoint a manufacturer. Let's say I appoint Dell, and I have a contract with Dell, by way of which I give right to Dell to go on only manufacturing the invention for which I have received 20 years exclusive right. Now, in this case, it will be considered to be a license, wherein I am transferring a right to manufacture or a right to make to Dell for a period of, let's say, 10 years. Now, this particular license has to be in writing, has to go on mentioning the rights and obligations. That means what all things Dell can do. It can go on manufacturing, what will be the payment which Dell will make me, because ultimately I am the owner of that patent. So, all the rights and obligation between Dell and me will be mentioned in that license agreement, and that license agreement has to be in writing, or it means typed. Writing means it should not be oral, it should not be verbal, and it must be registered. Now, the application for registration of such document, it should be made in form 16 within the time period which is mentioned under section 68. Once the document is registered, then and then only it will be considered to be a valid document. That means a valid license agreement. So, what rights can be transferred, what obligations can be put on the other party, it is between the parties to be decided. No third party can engage into it. Court cannot say that no, you cannot transfer this right, you cannot transfer that right. If I am the owner of that patent, I get exclusive rights, and I get a right to decide what I want to do on my own and what I want to transfer to the other party. Typically, there are three kinds of assignments. One is legal assignment, in which case the part of the patent, that means the assignee's name gets entered as an owner in the patent journal. So, the entire patent ownership is transferred to the assignee. It has to be done by way of a deed, which is known as the legal assignment deed, and it has to be again registered. So, in this case, the legal assignee becomes the proprietor of the patent and acquires all the rights which the original patent holder had. So, in case of legal assignment, the entire ownership is transferred to another person by way of a deed, by way of an agreement, by way of a contract, a registered contract, and all the rights of the original patent holder are now transferred to the new legal assignee. The other type of assignment is known as equitable assignment. So, any agreement, including be it a letter in which the patentee agrees to give certain defined share of the patent to another person, is an equitable assignment of the patent. However, an assignee in such case cannot have his name entered in the register as the proprietor or as the owner of the patent, but the assignee will have a notice of his interest in the patent registered. Now, to give you a small example, let's say I have a patent in which I have got certain rights. Take the same laptop example. I can get the ownership over the entire laptop, and I get the ownership of the entire invention which I have done, and I have got the patent for it. Now let's say I'm in India and I want to have a person in Europe who will capture the entire market in Europe with my invention. So what I do is that I transfer my rights, okay, I transfer my rights with respect to my invention for a specific region, for a specific country, to another person, and I tell that person that I will be the owner of this invention and I will be able to enjoy the exclusive rights only in India, and you will be able to enjoy the exclusive rights elsewhere. So in this case, I still have my name registered in the register of or the register of patent as the owner of the invention, but the interest in that invention is partially transferred to another person. The third type of assignment is known as mortgages. Mortgage is one such word which means that you have taken some amount of loan from the other person. That means once I take loan from a bank, I have to give some asset to the bank as a security. Tomorrow, if I don't repay that amount of loan to the bank will sell off that asset and get recover its money. That is known as generally as a mortgage. So in case of mortgage, it is an agreement in which the patent rights are fully or partially transferred to assignee in return for a sum of money. That means in return for the loan which the patent holder has taken. Once the assigner, that means once the patent holder repays the entire amount to the assignee, the patent rights are restored to the assigner or patentee. This is there just because patent is also considered to be a transferable property. So when I have a loan taken from somebody, I have to give some security to that money lender. In that case, if I give my patent as a security, it will be considered to be a mortgage. Once I repay that amount of money to that money lender, the money lender will give me back my documents along with the patent and the mortgage document, wherein again the ownership will be transferred back to me. This is known as a mortgage assignment. So in case of assignment, you can either go on assigning your entire rights with respect to the entire invention, wherein the entire ownership of the patent is transferred to the assignee, or you can partially go on assigning certain portion or certain interest in the invention to the assignee, or you can mortgage it as a security for the loan which you have taken from the other party. This is with respect to assignments. In case of license, like we said, the ownership or title is not transferred, but it is only certain rights which are transferred to the licensee. Section 70 of the Indian Patent Act allows the patent holder to grant a license by way of an agreement. By way of an agreement means in writing, it cannot be verbal, it cannot be oral. So a patentee by way of granting a license may permit the licensee to either make or use or exercise the invention, commercially exploit the invention, get the profit out of that invention. Unless and until it is in writing and it is registered, it cannot be valid. Now in this case, unlike assignment, I am not transferring my ownership, I am just transferring the rights. So obviously, if I am giving you right to use certain of my property, I expect something in return from you, right? Let's say I have a flat, it is my ownership, I am giving it to you on rent. In that case, I will not let you stay free of cost, correct? I will tell you that okay, you use my property for a period of 1 year. That means I am giving you this flat on rent for 1 year, but in return, you pay me a rent fee of 10,000 rupees. In patent regime, such money which is paid by the paid to the patent holder by the licensee is known as royalty, ROYALTY. You must have heard about this word earlier as well. Royalty means I am using somebody else's owned property, so in return I need to give some monetary benefit to that person. So royalty typically depends upon what sort of invention it is, what is the license terms and condition, what are the rights which are transferred. To give you another example, let's say a CCD owner. Now you must be knowing that CCD has got a franchisee. That means whatever CCD shops, cafe coffee day shops you might be seeing across, they are not owned by a single person. The ownership is different, but the owner has given right to many people to go on launching the CCD outlet and selling the coffee under the name of CCD. In that case, whosoever is using that name will have to pay the royalty to the owner. Likewise, in case of patent as well, if the licensee is utilizing the benefits of the invention, the licensee will have to pay a royalty to the license holder. That means to the patent holder. The licenses like assignment can be of following types. One is voluntary license, wherein the patent holder suo motu, that means on his own, by his own wish, goes on granting license to the licensee. Other type is compulsory license or statutory license, which we have already looked upon, wherein the government or any judicial authority or any law goes on granting compulsory license to the licensee. The next type is limited license or exclusive license. For example, the license to manufacture. If I am giving a license to manufacture to one party only, that means that person only can go on manufacturing my invention throughout the world, it will be considered to be an exclusive license. In case I am giving that person only a right to manufacture it only in Maharashtra, whereas I am giving another person a license to manufacture it in Karnataka, this is known as limited license, wherein limited rights are transferred depending upon area or depending upon duration. The last two types are express license and implied license. The word express means that it is specifically mentioned. For example, if I come up to you and I say that I want this pen for 10 rupees, are you ready to sell me this pen for 10 rupees? You agree to it, I give you 10 rupees, you give me your pen, it is considered to be an express agreement. But I just walk up to you, I stand next to you, I take the pen from your hand and I give you 10 rupees and I don't say anything. I do not ask you, I do not utter a single word, I do not take your permission. I just take the pen from your hand and I give you 10 rupees. This conduct of mine, this action of mine itself denotes that I want to purchase your pen for 10 rupees. Such type of contracts are known as implied contracts under the Indian Contract Act. Similar logic can be applied in case of licensing of patents, wherein in this case I am not expressly giving a license, but impliedly I am giving a license to the licensee to conduct few of the rights or to exploit few of the rights which I have received as exclusive rights. So this was all about assignment of patent and licensing of patent. In our next lecture we will be studying another important topic, that is infringement of patent, and what are the consequences of infringement and remedies available in case of infringement of patent. Thank you so much.